everyone, welcome back to our channel. Here we talk about popular niches like legal, digital marketing, AI, creative writing, and business journeys. I'll explain everything in an easy to understand manner, regardless of whether you're here seeking information or simply curiosity. We are delving into a subject that touches many people's lives, Indian divorce laws. Not every love story ends in happily ever after. Sometimes the road leads to separation, and that's okay.
You really think everything will be fine? तुम्हारा ये वाला साइड अगर पहले देखा होता ना तुमसे कभी प्यार नहीं करती. चलो लेट ही सही. Thank you for convincing me.
In this video, we're breaking down India's divorce laws in the simplest way possible. So whether you're going through it or helping someone else or just curious, you'll walk away with clarity, not confusion. India's respect for its culture and social ethics, one can guess that the divorce rate in India ranks lowest among all the countries in the world. Just 1 in 100 marriages end in divorce. But does that mean all marriages are happy? Not necessarily. Social stigma, family pressure, and financial dependence often discourage couples from separating, even when they want to. But now, because of rapid urbanization and awareness of various rights, the divorce rate is shooting upwards. And you'll be surprised to know that divorce rates in urban India have doubled over the last 2 decades. Yet, most people still don't know the legal steps involved. Let me clarify that there isn't a single universal strategy for divorce in India. There is no one-size-fits-all approach to divorce in India. Divorce laws are governed by personal laws based on religion. So basically, your religion is the basis for the laws. Christians rely on the Indian Divorce Act 1869. Muslims have the Dissolution of Muslim Marriages Act of 1939, and Parsis have the Parsi Marriage and Divorce Act of 1936. In case of a mixed faith or civil marriage, it's the Special Marriage Act of 1954. Now, for Hindu, Buddhist, Sikh, or Jain, it's a different reality. Many of these marriages are not registered legally and are performed through traditional rituals like the Saptapadi. We call them the 7 sacred rounds. In these cultures, a marriage is taken as a sacred ritual, not a legal contract. That's why there is no such thing as a Marriage Dissolution Act. Surprised by that? Comment below if you thought Hindu marriages were always legally recognized. I'd love to know what you believed before seeing this. Let's go into details. There are mainly 2 types of divorce under Indian law. One where both partners agree to part ways peacefully. That's called a mutual consent divorce. The other is contested divorce, where one person wants out and the other doesn't. Think of it like this. In mutual divorce, it's like 2 friends deciding to stop being business partners. In a contested divorce, one friend wants to leave the business, but the other wants to fight it out in court. For more like a courtroom tug of war, and things can get legally intense. And in such cases, the law doesn't just allow you to walk away. It requires specific legal grounds for the case to even move forward. And according to the Hindu Marriage Act, what are these grounds? Let's find out. Among the most popular are: number 1, cruelty, when one spouse mistreats the other, causing them to suffer physically or mentally. Second, adultery, in the event that one spouse has an affair outside of marriage. Third is desertion, when one partner leaves the other for a minimum of 2 years without providing a valid explanation. Fourth is conversion, when a spouse leaves Hinduism and converts to another religion. Fifth is insanity, when a partner suffers from an untreatable mental illness. Sixth is serious communicable disorders such as leprosy if they make living together dangerous. Seventh, renunciation of the world, when a spouse chooses to live as an ascetic or a monk instead of a normal existence. And eighth is presumption of death. This applies if a spouse goes unaccounted for 7 years. Now, let's talk about Christian couples in India. Their divorce proceedings are governed by the Indian Divorce Act of 1869. In reality, the Indian Divorce Act doesn't apply only to Christians. It also extends to Parsis and other communities in certain cases where civil marriages are registered under the Special Marriage Act, or where individuals seek divorce through the Indian legal system instead of religious customs. This act lays down divorce proceedings are governed by the Indian legal procedures and what follows after the marriage is legally dissolved. Let's break it down. For the husband, he can file for divorce only if he can prove that his wife has committed adultery during the marriage. For the wife, on the other hand, she has multiple legal grounds to seek divorce. These include if the husband has converted to another religion, if he has remarried while still legally married to her, if he has committed adultery with a close relative of hers, if he has married another woman after previously being unfaithful, if he has committed rape or sodomy, if he has been physically or emotionally cruel or has cheated on her, if he has deserted her willfully for at least 2 years. These legal provisions ensure that both spouses are protected and have access to justice based on their unique circumstances. Now, here's something most people don't talk about: the financial impact of divorce, especially on women. Even today, many women leave their careers after marriage or take on unpaid caregiving roles. So, when a marriage ends, they often find themselves without stable income or assets. That's where maintenance laws come in. Under Section 24 of the Hindu Marriage Act, either spouse can claim maintenance, but in most cases, it's the woman who applies. The court considers factors like earning capacity, responsibilities, and standard of living before deciding the amount. The details are as follows. Payment of maintenance. According to the Code of Criminal Procedure, 1973, there is no set amount. It really depends on what each party has. If the marriage was long, over 10 years, the maintenance could last for the rest of the life of the spouse or the partner. Distribution of properties. According to the Indian Divorce Act 1869, the court decides who gets what. The best interest of the child has to be looked into. Third is custody of children. Under the Guardians and Wards Act 1890, if both husband and wife want an amicable divorce, then they will decide who gets the children. Otherwise, it will be decided upon by the courts on the grounds of the best of the interest of the minor. In most cases here, mothers get custody and fathers pay alimony. Following the last section here, I'm going to bust 5 uncommon but widely believed myths that I often come across. And some of these might surprise you. Myth number 1. You have to talk in court in front of everyone about your personal life. In reality, divorce proceedings in India usually happen in family courts and privacy is respected. Your lawyer speaks on your behalf most of the time. Sensitive matters like domestic violence or adultery are handled in camera, that is privately, so you're not exposed to a public audience. Myth number 2. You lose all rights to a property or children if you file for divorce. In reality, filing for divorce does not strip away any of your rights. Property division depends on who owns what. In fact, courts prioritize the child's best interests, not just the gender of the parents. Myth number 3. Divorce is always a long, painful process that takes years. In reality, that's not true anymore. If both parties agree, mutual consent divorces can be resolved within 6 to 12 months. Yes, contested divorces can drag on, but even then, there are options like mediation, counseling, and settlements that can speed things up. Myth number 4. Once the court decides alimony, the money is given instantly. In reality, this is one of the most common misconceptions about divorce in India. People believe that once the judge announces the alimony amount, the money is immediately handed over. But that's not how it works. Let's break it down. Court decides the amount of alimony, either as a lump sum, a one-time payment, or monthly maintenance. Once the judgment is passed, it becomes legally binding, meaning the paying spouse is required by law to give the money as per schedule. But the court does not monitor whether the payment is actually made. Did you know? As per reports, around 65% of women entitled to maintenance in India never receive it in full due to enforcement issues, delays, or out-of-court settlements. Shocking, right? Comment below your thoughts. I'm curious to know your perspective on this. Now, what will actually happen if the payment isn't paid? If the spouse refuses to pay or delays the alimony, the court won't automatically take action. Let me unfold what happens. The aggrieved party, usually the wife, has to file an execution petition in the same court that issued the order. The court can then summon the defaulting spouse and order recovery of dues. If the default continues, the court can attach property or salary, seize bank accounts, or even issue arrest warrants in some cases. But this whole recovery process takes additional time, legal fees, and follow-up. Divorce is tough, and the legal process can feel overwhelming, but knowledge makes it easier. Let me ask you now, what do you think? Should divorce laws evolve to reflect modern relationships better? Answer in the comment section, and we love reading your perspective. If this video helped you even a little, consider hitting that like button and subscribing for more legal insights. And hey, if you know someone going through a difficult separation, share this with them. It might just give them the clarity they need.